my lord. Even though it is fixed for today, my lord, I'm having a personal difficulty today, my lord, and so it may be posted again next week, my lord, if your lordship pleases.
Part 2 list.
Yes.
Where is the part 2 list?
Item 7 of part 2, my lord.
What is your name?
Lalbiak no namte, my lord.
Heard Mr. Lalbiak Kunga Namte, learned counsel for the appellant. Also heard Miss Mary L. Kyangte, learned counsel, learned additional public prosecutor. Learned counsel for the appellant seeks an adjournment. On what ground? Due to personal difficulty.
Yes, my lord.
The prayer is not opposed to by the other side, hence same is allowed. Let this matter be listed. When do you want?
My lord, anytime next week, my lord. Let it not be fixed. Let it come up in the hearing list because.
Let this matter be listed after a week on a date to be listed, fixed by registry.
Yes, deeply obliged, my lord.
Please, Your part 2, item 9. Your Worship, I had requested it to be taken up today, but there are some matters above us which are fixed for today. So if this can come up tomorrow.
Okay.
Item 9.
Okay.
No order is required.
Okay.
Daily list for motion, item 1.
May it please your lordship, this is a matter of additional increments which are to be granted to the nursing staff, my lord, and has been covered by several judgments and orders, my lord. We are the petitioners who have been appointed, recruited by the respondents, my lord, and our posts have been confirmed by the respondents. Our post, which I have listed in the table at page number 13 of my petition, my lord.
Okay,
Petitioner, page number
Will issue notice.
My lord, the matter has been covered, squarely covered by several judgments and orders, my lord, which I have also listed in my petition, para number
What is the
5.
respondents?
Your Lordship, my humble prayer is to have the notice issued at this stage for ends of justice, because this is the first time I'm holding the brief, so as to satisfy ourselves that it is a covered
We
matter.
are issuing.
My lord, if I may, this matter has been squarely covered and all
No,
the
but
other judgments have...
Let them go through your petition if
My lord.
required.
If the matter may be fixed next week, my lord.
Yes, Miss Mary.
Yes, Your Lordship, next week, Thursday,
Will you be filing any
that we have to go through the
Instructions. Okay,
file first, Your Lordship.
heard?
No, my lord, I am sorry, I apologize. I am going for a medical checkup next week.
Then after a week,
Then after a week.
heard Miss H. Lalmal Swami.
Valentina Dinpui, my lord.
Sorry, heard Miss Valentina Laldingpui, learned counsel for the petitioner. Also heard Miss Mary L. Kyante, learned government counsel appearing for all the respondents. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner, namely Srimati Vanlal Feli and 19 others, praying for
My lord, 20 others.
how many?
21 in total.
20 others.
Yes.
20 others, praying for grant of increments to the petitioner who are presently posted in different posts of nurses, tutors, lecturers, etc. by the respondent. Issue notice to the respondent. Since Ms. Mariel Kante has appeared for all the respondent, no formal notice need to be issued. However, you have received the copies?
Yes, Your Lordship, duly received.
Yes. Learned Government Counsel, Learned Counsel for the petitioners has submitted that the case of the petitioners are covered by the earlier judgments rendered by these courts, and therefore necessary directions may be passed even today. However, Learned Government Counsel submits that she may be allowed some time to take necessary instructions in this regard. The prayer is allowed. Let this matter be listed.
23rd, my lord.
23rd,
Third, Monday.
On 23rd of February.
Much obliged.
For admission, item 2.
Your Lordship, we have sent the affidavit, a show cause reply affidavit to the respondents, and we have received from the Secretary School Education and Finance, which we will be filing today. But then the rest, we will have to wait some time.
Affidavit of compliance, you have complied?
Substantially complied, but then not fully complied, and then we have sought an extension of time for compliance by way of interlocutory application, which at the moment is withdrawn, and then with the liberty to file afresh because there was some technical defects.
When will you be filing?
By tomorrow, Your Lordship.
If they are filing by tomorrow, my lord, let us go to the examine time. Give us time to examine the affidavit, and the matter may be taken up again on Tuesday, next week, Tuesday, on
Yes,
10th
I
of
think that
February.
would be best.
Okay. Heard Mr. Victor K. L. Ralte, Learned Counsel for the petitioner. Also heard Ms. Mary L. Kante, Learned Counsel for respondent number 1, 3, 4, 7 and 11, who submits that she may be granted some time to, who submits that the affidavit to be filed by the respondent is ready and they are going to file it by tomorrow. Learned Counsel for the petitioner submits that in that case some time may be granted to the petitioners also, so that they may go through the same and request this matter to be listed on
Tuesday, 10th
Tuesday,
of
that is
February.
10th of February. The prayer is allowed. Let this matter be listed on 10th of February.
Deeply obliged.
Item 3.
Item 3, Your Lordship, I've just received the additional affidavit filed by the respondents, Your Lordship. So if I may be given about a week's time to go through it.
Okay. Heard Mr. A.R. Malhotra, Learned Counsel for the petitioner. Also heard Mr. L.H. Lian Shrima, Learned Senior Counsel, assisted by Ms. Ruth L. Lal Feli. Learned Counsel for the petitioner has submitted that he has received the
Additional
additional affidavit filed by the respondent. When? Today?
Your Lordship,
Recently.
For our second, Your Lordship.
And seeks some time so that he may go through the same before he makes his submission. The prayer is allowed. Let this matter be listed. After, you want a fixed date?
23rd?
After a week,
23rd February?
on 23rd February.
I'm
Item 4.
26th.
Yes. What is this?
Your Worship, this matter may kindly be taken up for admission hearing on the 26th. Your Worship. Pleadings are complete.
Then we'll
Fixed it for 26th.
admit it and fix it for hearing.
No, my lord, admission stage itself, it's possible, my lord. My
Admission-
lord, the reason is because, my lord, this case, my lord, this case is with respect to the appointment of the registrar, the respondent number 5.
No, no. What I am suggesting, it is coming up for admission hearing on many days. So let us admit it and fix it for hearing.
We have no objection, my lord.
My lord, will it be possible, my lord, for this matter to come up on 26th as an admission hearing only, my lord?
Okay.
We'll try and dispose it off at the admission stage itself, my lord.
Heard Mr. Joseph L. Rentley, learned counsel for the petitioner. Also heard Mr. L.H. Lian Shrima, learned senior counsel assisted by Ruth Lal Ruatfeli. Lal Rem Ruatfeli. Lal Ruatfeli. Learned counsel for respondent number 1 to 5. Also heard Mr. A.R. Malhotra, appearing for respondent number 6. It is submitted at bar that pleadings are completed in this case and this matter may come up for admission hearing on
26th.
26th of February. The prayer is allowed. Let this matter be listed on 26th February.
Obliged, my lord.
Item 5.
If I may, my lord.
Yes.
If I may, my lord. In this matter, I've learned that the records have arrived. So, kindly allow me 2 weeks to go through the records and then properly assist the court. My lord, there are two of the grounds which I would take is that there is an absence of the go down receipt to which the seizure was kept, and one is the absence of mandatory provisions of section 50, wherein the arrested person has to be informed of his discretion whether he should be checked before the magistrate or the gazetted officer, within the presence of the gazetted officer. I have to check the records.
Okay. Heard, Mr. What is your name?
Mga isang appearing on behalf of my senior, Mr. Johnny Mayo.
Lalmangya Sangha, learned counsel for the petitioner. Also heard Ms. Lalru Kunga Pautu, learned legal aid counsel appearing for respondent number
1 and 2.
1 and 2, who submits that, who prays for some time to go through the records of the trial court which have been received by the registry before he makes his submission in this case. The prayer is allowed. Let this matter be listed after 2 weeks.
Obliged.
Item number 6 and 7.
My lord, in this case, I appear for the petitioner in item number 6. And so we have received an affidavit that has been filed by the respondent number 9. Now, my lord, with respect to item number 7, we are filing our Vakalatnama, my lord, with respect to the respondent number 8 today, during the course of the week, my lord. So we will be representing the respondent number 8.
My Lord, so far as item number 6 is concerned, I am appearing for the respondent number 8. I'll be filing my affidavit during the course of the day. And in item number 7, I am for the petitioner.
So, my lord,
In
item number
in item 7, I have instructions to appear on behalf of respondent 7, Your Worship.
Okay.
I will be filing my power within the week, Your Worship.
In item number 6, right, in item number 6. Who is the petitioner in item number 6?
My lord, I appear for the petitioner, my lord.
Heard Mr. Joseph L. Renkley, learned counsel for the petitioner. Also heard who submits that he has received the affidavit in opposition filed by respondent number 9 in this case.
And
Also heard
respondent 7 also, Your Worship. We have also filed.
respondent number 7, 9 as well as 7 in this case. Also heard Mr. A.R. Malhotra, who appears for respondent number 7. You have filed Vakalatnama?
We have filed affidavit also.
Okay, okay. As well as Mr. Victor L. Ralte. What is your prayer?
I'll be filing my affidavit during the course of the day
Who
on behalf of
submit-
respondent number 8.
Who submits that he would be filing the affidavit on behalf of respondent number 8 during the course of the day. When can we fix the matter? After 2 weeks?
After 3 weeks, my lord. No, the reason I'm saying 3 weeks, my lord, is because with respect to item number 7, we will have to file our reply.
Okay.
That's the only reason, my lord.
The reason why I'm a bit in a hurry is because there's a stay order in
Okay,
response-
let this
favor of
matter
the
be,
petitioner,
let this
item
matter be
6.
listed after 2 weeks. 2 weeks. In item number 7,
And my lord, interim pass earlier may continue item number 6 then.
the interim order is there. In item number 6.
Item number 6, my lord.
The interim order shall continue till next day. In item number 7, heard Mr. Victor L. Ralte, learned counsel for the petitioner. Also heard Mr. Joseph L. Rentley, learned counsel who submits that he will be appearing for
Respondent number 8.
respondent number 8 and would be filed. You have filed Vakalatnama?
No, we'll file our power during
Would
the
be
course of the
filing his power during the course of the day. Mr. A.R. Malhotra, learned counsel, has also submitted that he would be filing his power on behalf of respondent number 7 during the course of the day.
My lord, week, because the clients are yet to sign, my lord.
Within
2 days.
2 days.
within 7 days.
7, yes, my lord.
Within 7 days. Let this matter be listed along with WPC number 2/2025 after 2 weeks.
Obliged, my lord.
Item 8.
Your motion, this is a contempt petition against the willful non-compliance of the order of this honorable court dated 11/8/2023 in WBC 76 of 2022, Your Lordship. My Lord, the counsel for the NF Railway have submitted his Vakalatnama and has appeared on several occasions. However, affidavit in respect of all the respondents have not been filed till date, Your Lordship. And in the last court order, Your Lordship would see that in the last paragraph, Mr. H. Gupta Lalakazas submits that he will positively take step to file pleading affidavit by the next court date. And we have not received that, Your Lordship. And in the meantime, on another matter is that we have come to learn that Your Lordship that
What was the order which has been violated? What was the direction?
the direction was for the payment of interest under Section 34 of the Land Acquisition Act. of the
Okay.
petition.
You have received the other compensation amount you have received
The compensation we have received
only for interest.
only for interest.
Yes, Mr. Gupta.
My Lord, in this matter, my Lord, earlier respondent number 4, 5 and 6, my Lord, they are no more in the position, my Lord, and in my humble submission, my Lord, a new incumbent needs to be implemented. And my Lord, although affidavit was ready, my Lord, but the respondent number 6, my Lord, who was recently implemented by the petitioner, and he is the person, my Lord, who will file the affidavit on behalf of other respondents. He has now also been changed, my Lord, and new incumbent has come. So, my Lord, on that, my Lord, ground, I pray for some time to file affidavit. And further, my Lord, the subject matter of this case, my Lord, that is regarding payment of interest under section 34, my Lord, the matter is sub judice before the Honorable Division Bench, my Lord, in a writ appeal. There are many cases, my Lord, filed by the landowners, my Lord, claiming compensation under both section 28 and 34. Whereas the contention of the railway is that, my Lord, the interest can be paid only under one of the sections, my Lord. So these are also, my Lord, similar cases, my Lord, where the landowners, although they have got interest under one of the provisions, my Lord, they are subsequently they have filed writ petition claiming interest under section, my Lord, another section, that is section.
Mr. Gupta, you state these,
My Lord, I will state
these
it in the
things in your
affidavit, my Lord.
affidavit. File your affidavit
My Lord,
immediately.
my Lord.
My Lord,
My Lord,
the
my
matter
Lord.
is that whatever the other cases are, we cannot have a hold of the contempt. The order is there, so
Yes.
the court has to have to go on with this, Your Lordship. And but my learned friend has says that, my Lord, in the beginning there were only 5 respondents, and Your Lordship will see that the respondent number 5 has been replaced by respondent number 6.
Now, my Lord, 6 has also been, my Lord, transferred. That is my, I will pray my learned friend, my Lord, because ultimately the new incumbent has to be implemented. Then only, my Lord, I can file the affidavit. Otherwise, if the authority is not there, my Lord, they will not be able to swear the affidavit. So, my Lord, the new incumbent is, well, I have been informed that respondent number 6 is now no more in that position, my Lord, and the new incumbent has come. So, my Lord, in my humble submission, my Lord, I think there is a necessity of implementing that new incumbent, my Lord.
My Lord, my learned friend is correct. If Your Lordship will allow us, we will implement respondent, the new incumbent for the respondent number 6, Your Lordship, if Your Lordship permit. And regarding respondent number 4, we are not sure whether there is a new incumbent.
4 is also not there. 4, 5 and 6.
Heard Mr.
They both are-
Jonathan L. Silo, learned counsel for the petitioner. Also heard Mr. H. Gupta, learned standing counsel railways.
My Lord, CGC, my Lord.
Learned Central Government Council, appearing for the respondent side, who submits that the erstwhile incumbent of the post of Chief Engineer Construction / Aizol in charge of Kwan Kui and Bhairavi NF Railways has been transferred, and therefore there is a necessity of implementing the new incumbent of the said post by the petitioner. He submits that for the said reason the respondent has not been able to file their affidavit in opposition and seeks some time for the same. On the other hand, learned counsel for the petitioner submits that in view of the change of incumbent to the post of respondent number 6, they may be allowed to take necessary steps for implementing the new incumbent as a respondent in this contempt case. The prayer is allowed. The petitioner may take steps for the same within 2 weeks, from the date of this order. List this matter after 2 weeks.
Obliged.
I'm obliged.
Item 9.
Yes.
At the outset, my lord, I would like to point out that the respondents here in 1 to 5 had served me a copy of an affidavit, so-called reply affidavit, and I believe that has already been filed.
Who is appearing for respondent number 5?
1 to 5.
Yes, Your Lordship. We will be filing our affidavit tomorrow, Your Lordship. It's already prepared and ready. Notice is
Tomorrow?
also, yes, Your Lordship.
Heard
This
Mr.
may come up again on next Tuesday, my lord, if they are filed by
Next?
tomorrow. Tuesday.
Okay. Heard Ms. Victor L. Ralte, learned counsel for the petitioner. Also heard Ms. Lalnan Ului, learned government advocate, appearing for all the respondent, who submits that she would be filing the affidavit in opposition by the respondents tomorrow, and therefore prays for listing this matter in the next week. The prayer is allowed. Let this matter be listed on 10th of February.
Much obliged, Your Lordship.
Item 10.
May it please Your Lordship. My Lord, the instant petitioners are owners of lands under periodic patas. My Lord, the nature of their land holdings, these are reflected at paragraph number 2, page number 7, with their respective period of validity, my Lord. And also, I have annexed copies of the periodic patas, which are from annexure number 1 to 17, my Lord. And my Lord, on 9/09/2019, a notice inviting tender was issued by the instant respondent number 8 for construction of roads under PMGSY scheme.
Yes.
Yes. And my Lord, construction of How Long to Dawn Road, this has been reflected at serial number 21 to 25. This is at page number 9. I have reproduced this set notification at paragraph number 3.
Page number?
Page number 9 at paragraph number 3. And I have also annexed copy of this NIT 09/09/2019 at annexure number 18.
Yes.
Yes, my Lord. And my Lord, construction of roads under this PMGSY scheme was done. However, my Lord, this road runs over the lands of the instant petitioners. In fact, the petitioners, the areas of lands, as well as the affected, how they were affected, my Lord, this I have mentioned at page number 11, paragraph number 5. How each of the lands of the petitioners have been affected, my Lord, this I have mentioned at paragraph number 5.
How it was affected?
My
By
lord,
dumping loose soil in
Yes.
your land.
Yes, my lord. And in respect of...
Now what is the condition? Road has been constructed.
My lord, completed.
The soil has been removed.
No, my lord.
It is still there.
Yes. And so the excavated soil has just been pushed into the lands of the petitioners. And also, my lord, in respect of the petitioner number 1, if your lordship will see paragraph number 5, page 11.
Yes.
193 square meters of the land has been used as a dumping ground. And with respect to, in respect of the respondent, petitioner number 2, my lord, the land was used as an illegal dumping ground in case of one periodic pata. In case of another, they had destroyed some teaks, 2,000 numbers of teaks, and destroyed 6,300 square meters of land. And so forth, my lord, I have specifically mentioned, yes, described how the lands of the petitioners, each petitioners are affected, my lord. However, my lord, in spite of this, the lands of the petitioners being affected by construction of this road, no compensation has been given. And I am before this honorable court praying that as joints, that a spot verification may be conducted, and that, my lord, that the respondents be directed to acquire the lands of the petitioners which have been actually affected by construction of the road, and to pay compensation as per law, my lord. That is my humble submission before this honorable court. And I have also placed some judgments of this honorable court, wherein the roads under PMGSY scheme has been given compensation, my lord. This I have placed at Annexure 21, page 72. Page number 72. This is in the case of WPC number 71, 2016, which is disposed of by this honorable court on 14/09/2016. This particular road, my lord, pertains to Zonghun to Mauchar and Zonghun to Palsang road under PMGSY scheme. And here the respondents, the operative portion is at page number 80, paragraph 10.
Page number?
80. Page number 80, paragraph 10. If I may read, paragraph 10.
Yes.
In the facts and circumstances of the case as discussed herein above, this writ petition is disposed of with a direction to the respondent, more particularly the respondent number 4, that is the District Collector Aizawl, District Aizawl, to forthwith take steps for acquiring the land of the petitioners over which the construction of road from Zonghun to Palsang village has been covered by their respective periodic patas.
No, but in your case, road does not run over your land.
My lord, road,
it is only
no.
The excavated soil has been dumped.
Road runs over my land, as well as excavated soil has been illegally dumped. And that construction of the roads has also, my lord, destroyed my crops. This has not been denied by the respondent, my lord, in the affidavit filed by the respondents, my lord. They have acknowledged that road runs through private lands, and that this construction of road has also affected the lands of the petitioners, my lord. If your lordship will see the affidavit filed by the state respondents, paragraph number 4, paragraph number 5, my lord. They have not denied this. And more recently, my lord, if your lordship could kindly come to page number 87. Page number 87 of my petition, annexure number 24. Page number 87, annexure 24, WPC number 97 of 2023. Where in this honorable court by its order dated 23/01/2024. Had directed spot verification to be conducted over the lands of the petitioners, which was affected by construction of Leng Te Road, my lord, Leng Te to Sairang under PMGSY scheme. And thereafter, to acquire the lands of the petitioners as per the 2013 Land Acquisition Act, my lord. So, my lord, my humble prayer before this honorable court is that let a direction be passed for conducting verification.
Yes, Mr. Samuel.
Yes, my lord. May it please, my lord. My lord, as stated earlier in paragraph number 4 of the affidavit in opposition filed by us, my lord. Page 2, my lord.
Yes.
Wherein we had stated in our affidavit in opposition, my lord, that the road passes through some agricultural lands of the nearby villages, my lord. Some. That's the use of the word, my lord, out there. But however, my lord, what had happened was that a meeting was held between the officials and village councils and NGOs of each village to obtain permission for construction of the road, my lord. Now, if I may kindly take your lordship to page 63, my lord.
Of your
affidavit in opposition, my lord. Page 63 is the first one, my lord.
Yes.
This is, if we read on top, my lord, Pradhan Mantri Ram Sadak Yojana, PMGSY. Below that, my lord, is an affidavit for land donation. In the previous other referred matters, my lord, those lands may not have been donated, but in this present writ petition, the lands have been donated for the construction of this particular road, my lord. Now coming to point number...
Who has donated this?
These are the landowners, my lord.
Is he a petitioner in this case? And whether land can be donated by swearing affidavits?
They have signed an agreement. That is what I'd like to...
No, but can this be a mode of donation of land? It has to be by accepted modes only.
Coming to point number 2, my lord, if I may.
Of page 63?
Yes, my lord.
Yes.
Wherein out there it has been stated that under the PMGSY road is to be constructed, which will be of benefit to all residents of the areas. Accordingly, I hereby agree to donate a portion of a land, my lord. Not the whole land.
And what is donated that is left blank? What is that portion?
Yes, my lord.
So neither the donor knows nor the donee knows.
No, the length or the width of the road has been mentioned. And at point number 4, my lord.
Whether any of the 17 petitioners have so
And again at point number 4, my lord, of the same affidavit.
Yes.
If I may read, my lord.
Yes.
My successor would not acclaim any compensation against the above said portion of land. So this is the affidavit signed by the landowners pertaining to this particular road, my lord. And there on the bottom right side, the deponents' names and signatures are there.
Who is this? Which petitioner? Petitioner number?
No, this is not the. These are not the petitioners, man.
Whether is he a petitioner?
No.
Before the court.
No.
Page 63 to my lord. Page 209 are the agreements, my lord, all annexed. I'll have to check which are the writ petitioners and which are not, my lord.
No, that you have to state.
Yes, my lord.
If you are relying on those agreements.
I can make a chart, my lord, if your lordship will permit.
When?
2 days, my lord.
This is not a very complex matter.
Yes, my lord. 2 days. We can take it up next
Okay,
Tuesday.
let him find out.
My lord.
Otherwise, what is your submission regarding validity of such affidavits?
They have willingly donated as per my submission, my lord, and as per the agreement has been signed. And they have specifically stated in the agreement that they will not claim any compensation for the portion of the land that might be acquired for the road construction.
Okay, you find out.
Yes, ma'am.
Heard Mr. T. Lalzek Kima, learned counsel for the petitioners. Also heard Mr. Samuel Van Lal Shriyata Chante, learned additional AG, appearing for the state respondents. During the course of hearing, it was pointed out by the learned additional Advocate General that the road constructed under under what?
PMGSY.
PMGSY scheme by the respondents runs through some of the agricultural land of the nearby villagers. However, those villagers have voluntarily donated the portion of land which is used for construction of the road, and in acknowledgement thereof they have also shown affidavits and agreements thereto. Learned additional AG prays for 2 days time so that he can verify and prepare a list as to whether the petitioners before this court have also donated the land. The prayer is allowed. Let this matter be listed on
Tuesday 10th.
Thursday.
Tuesday.
Tuesday.
Tuesday 10th.
Okay, on 10th of February.
For orders, item 11.
Please, Your Lordship, trial court record has been received by the registry and a paper book may be prepared, Your Lordship, at the expense of the appellant.
Paper.
Item 12.
May I please, Your Lordship? My Lord, the instant IA is for staying the operation of the impugned order, my Lord, dated 20/01/2025.
What is the order?
My Lord, they have challenged the impugned judgment and order passed by the
This is
civil court.
Page number 9, my Lord.
Of the IA?
Yes.
What it says?
My Lord, I apologize, my Lord. This is from page.
This is an eviction suit. Suit has been disposed of.
Yes, my Lord. Suit has been disposed of.
Whether any
Suit was disposed of. My Lord, I'll just give you a
Page
lordship
number
the facts of the case, my Lord.
Huh.
Eviction suit was filed by two people, my Lord. Plaintiff number 1 and plaintiff number 2.
You are the plaintiff.
No, I was the defendant number 1 in this case. Defendant 1 and 2, my Lord.
Okay.
And the state director also was implemented as defendant number 3.
You are the appellant in this case.
No, I'll tell you, Lordship, my Lord,
Okay.
what happened. Now, the suit was decreed in their favor for eviction.
Okay.
The whole point, the strength on which they had filed their eviction suit was on a land settlement certificate document, my Lord, in the name of the plaintiff number 1. Now, after the suit was decreed, my Lord, we came to know through official records, my Lord, that the defendant, that the plaintiff number 1 was not an existing person only. She had never existed, I mean, according to the records. There was no voter ID in her favor. The locality she claims to be from, they have no idea who she was. The Vakalatnama submitted in court, my Lord, did not have her signature. The court records has no signature of this plaintiff number 1. We found this out after the decree was issued, decree in their favor. So we filed a review petition, my Lord, before the same court. Now, so the review court, my Lord, interfered with original decree and set aside the decree. Reversed the decree, but then what it did was, my Lord, there is a Supreme Court, there's some Calcutta High Court judgments on this. It has decided to frame a new issue to be tried on whether she is an existing person. Plaintiff number 1. Now they are dissatisfied with that judgment and order, my Lord, that review order, and they have come to this court. Now they are asking for stay of this judgment and order, my lord, of the review court. My humble submission, my lord, at this stage is if they want to pursue this stay order, my lord, we can take this up, my lord, tomorrow, because we will have to go into the merits of the case, my lord, for stay order to be issued. We can take it up tomorrow, my lord, and we can see if they have any case. If they don't have, because we can dispose it off once and for all, my lord. In fact, my lord, there is no reason for stay. The reason I'm saying this, my lord, is because the only reason they could have asked for stay, my lord, in this case is because the matter is sub judice. It's not as if this has been disposed of. There's supposed to be a trial before the senior civil judge. Now the entire record has been called by this court, and it is in this court, my lord.
The case is otherwise not proceeding.
It's not proceeding. So the issue of stay does not arise. But if they want to still proceed, my lord, I think the only option available is if we pursue the whole matter, my lord, because we'll have to do the final hearing only.
Yes. We'll dispose of the appeal.
That can be done, my lord.
Instead of...
Yes. Tuesday. Then, my lord, tomorrow?
If this matter can be listed next week, because tomorrow I have personal
When?
difficulties. Next week on Monday.
No, Monday we have many cases. Thursday? Thursday is possible.
My lord.
This is item number 12.
12.
Heard Mr. Lal Fakwama.
Tila Zekima, my lord.
Tilal Zekima, learned counsel for the appellant / applicant. Also heard Mr. Joseph L. Rentley, learned counsel for respondent number 1, as well as Miss Caroline, learned government counsel, appearing for respondent number 2. Learned counsel for respondent number 1 has submitted that the appellant has filed this interlocutory application praying for stay of the impugned judgment and order. However, as the trial court records have already been requisitioned by this court in connection with this appeal, in connection with the connected appeal, the trial is otherwise also not proceeding, and therefore he submits that the connected first appeal may be heard instead of taking up the interlocutory application. The other counsels, including the learned counsel for the applicant / appellant, does not oppose the prayer. Hence, let the connected appeal be fixed for hearing. Appeal has been admitted.
No, my lord. No, my lord. It's in the order state.
Appeal be fixed for admission hearing. We will try to dispose it off.
Yes.
On which date?
My lord, is it 12?
On 12th of,
Thursday is 12.
12th of February.
Deeply obliged, my lord.
Item 13.
My lord.
Yes.
My lord, in this matter, I've recently been engaged to represent the respondent number 1. So, my lord, I'm seeking 2 weeks' time to file my written objection to the condonation of delay.
Oh. What is your name?
Lal Mangai Sanga. I'm appearing on behalf of my senior lawsuit, Mr. Johnny.
Heard Mr. What is his name? Lal Mangai Sanga. Lal Mangai Sanga, learned counsel for the applicant. Also heard Mr. Lalro Kunga Pautu, learned legal aid counsel,
My lord, it's my personal capacity, sir.
learned counsel for the respondent who seeks 2 weeks time to file written objection against the prayer for condonation of delay filed by the applicant. The prayer is allowed. Let this matter be listed after 2 weeks.
Obliged.
Hearing list, item 5.
Mayor, please, Your Lordship.
Yes.
Lordship, this is an appeal by the state against the judgment and award dated 14/2/2025.
State has appeal.
Yes, my lord. State
Item
appeal.
5. Okay, okay. Yes.
This is an appeal against the judgment and award dated 14/2/2025, wherein the learned tribunal had awarded rupees 23,30,000 to the respondent claimants. Hence, being aggrieved by this appeal has been filed. And my lord, if I take your lordship to the brief facts of the case, it's in my memorandum of appeal. At page 3. Also, my lord, I have prepared a short note.
Yes.
Page 3 of my memorandum of appeal. Lordship, not the paper book, my memorandum of appeal.
Yes.
The brief facts of the case is that initially the present respondent, who is the claimant of the said MACT case number 38 of 2022, had filed an application under section 166 of the Motor Vehicle Act 1988 on 11/10/2022, claiming compensation for the death of her late husband, Sri Kelal Engmoya, son of Kelal Ming Liana late, residents of Tan Mari West, Aizawl, who she claimed died in a vehicular accident on 18/11/2011 at about 6:30 p.m. involving an MST bus bearing registration number MZ01D2250, driven by Sri Kelal Lomsanga, son of Kelal Bela, resident of Tan Mari West, wherein the said vehicle met with an accident at Si Mui, Aizawl, near Mr. Seltunga's garden. That according to the materials available on record, one, Sri H. Laltsoy, who was the then officer in charge, Sairang Police Station, Aizawl, submitted an inquiry report bearing reference number such and such to the officer in charge, Sairang Police Station, Aizawl, and the same was received and registered. In other words, the said Sri H. Laltsoy submitted the said inquiry report to himself, which he himself registered as the aforementioned. It may be pertinent to mention herein that at the outset that this fact was admitted by the said Sri H. Laltsoy himself before the learned MACT Aizawl, other than also admitting that he was the case investigating officer regarding the same. That thereafter a charge sheet in connection with the case bearing such and such was submitted by the same. It was averred in the charge sheet that the accused person, Sri Kelal Lomsanga, consumed alcohol and was drunk at the time of the accident on 18/11/2011 and was driving the bus in a speed which led to the accident. Thereafter, the case was registered before the learned trial court as criminal trial number 2622/2011. Dated 19/11/2011 under section 279-338-304A of IPC, read with 185 of the MV Act, to which consideration of charge was conducted upon the then accused person, Sri Kelal Lomsanga, who was the driver of the MST bus. However, the learned trial court discharged the said accused, Sri Kela Lomsanga from all liabilities leveled against him on 23/10/2012. The relevant portion of the order dated 23/10/2012 issued by the learned JMFC First Class Aizawl Mizoram is reproduced herein for ready reference. After hearing both the parties and also from the statement of the accused, it appears that the vehicle in question met with an accident while the same was hired out by the government, that is Transport Department. The accused was also detailed to drive that vehicle by the hire authority, and that vehicle was under repair for a long time. In the above circumstances, I hereby discharge the accused from all liabilities leveled against him in this instant case. The case is hereby disposed of accordingly. That thereafter, a span of more than 10 years after the said date of accident, that is 18/11/2011, the respondent herein, who was the claimant in the said MACT case, preferred an application under Section 166 of the Motor Vehicle Act 1988 on 11/10/2022 before the learned MACT Aizawl. As per the materials available for the present appellants, it appears that along with her claim application, the respondent/claimant annexed certain documents in support of her claim, including marriage certificate titled in name, a certificate birth and death certificate of the deceased, charge sheet, a letter titled Shatrina dated 7/9/2022 issued by the Young Mizo Association, Tanari West Aizawl, and an undated letter titled to whom it may concern issued by J. Laranwata Advocate. The appellants herein, who were the opposite parties before the learned MACT Aizawl, also accordingly filed their written statements. That thereafter the learned MACT Aizawl framed the following issues from the pleading of parties, which is reproduced herein for ready reference. Whether the present claim application is maintainable in its form and style, whether there was fault on the part of the driver or owner of the accident vehicle, whether the claimant is entitled to get compensation, if so, who is liable to pay and to what extent. That in order to substantiate her case, the respondent claimant herein examined as many as 5 witnesses, including herself. Claimant's witness number 1, Zhou Mingtong, wife of Lal Ing Moya, late. Claimant's witness number 2, H. Lal Choi Moya. Claimant's witness number 3, K. Sang Kuni. Claimant's witness number 4, Lal Mwanki Matsote. Claimant's witness number 5, Zhou Sang Zwali. All the said witnesses were examined, all of whom have failed to satisfactorily prove the respondent claimant's entitlement to her claim. The appellants herein also adduced their evidence by calling 2 witnesses, namely Sri Kela Lomsanga, the then driver of the said MST bus, and Sri Lal Mangai, the then conductor of the MST bus. However, without properly considering the evidence of both parties and the law applicable to the case, the learned MACT Aizawl was pleased to pass the impugned judgment in a word dated 14/2/2025 in favor of the present respondent and against the appellants. The present appellants were accordingly directed to pay compensation to the respondent claimant as according to the following, which is reproduced herein for ready reference. As such, the opposite parties, Transport Department, Government of Mizoram, is directed to deposit a sum of rupees 23,30,000 only, along with interest at the rate of 7% per annum from the date of filing, that is 11/10/2022, to this tribunal through NEFT or RTGS in favor of the presiding officer, Motor Accident Claims Tribunal, for onward disbursement to the claimant. The opposite parties shall make the deposit within 1 month from the date of this judgment and awards. Thus, being highly aggrieved and dissatisfied with the said impugned judgment and award dated 14/2 passed by the learned MACT, the appellants beg to prefer this instant appeal on the following grounds. Now, my lord, my first ground is with regards to non-consideration of inordinate delay in filing claim petition. The learned MACT Aizawl has miserably failed to apply its judicial mind by entertaining a claim petition filed after grossly inordinate and improperly unexplained delay of approximately 10 years, 10 months and 23 days. The accident in question having occurred on 18/11/2011, while the claim petition appeared to be filed only on 11/10/2022. It is to the best knowledge of the appellants, although not admitted, and is fairly submitted, not admitted by the appellants, that at the time of the accident, the governing statute would be the Motor Vehicles Act 1988 as amended by the Motor Vehicles Amendment Act 1994, which had, with effect from 14/11/1994, deleted the limitation provision previously found in Section 166, Clause 3, thereby removing any prescribed statutory period within which a compensation claim was to be filed. This regime changed when Parliament enacted the Motor Vehicles Amendment Act 2019, which through Section 53 introduced Section 166 Clause 3 into the Parent Act, thereby providing that no application for a compensation shall be entertained unless it is made within 6 months of the occurrence of the accident, and that this newly inserted provision was notified by the central government to come into force prospectively with effect from 1/4/2022. White Gazette notification dated 25/2/2022 issued by the Ministry of Road Transport and Highways, Union of India. In the present case, although the accident dated 18/11/2011 took place long before the amended provision came into force, the appellants also fairly submits that to the best of their knowledge not admitted, the newly introduced limitation under Section 166 Clause 3 appears to be prospective in operation, does not seem to apply to the claim at hand in the instant case, as the governing act is a welfare legislation. That, however, while the same may, although not admitted, technically exempt the claim from being summarily barred under the 2019 amendment, it does not absolve the respondent claimant from the obligation to offer a concrete and credible explanation for filing a claim after nearly 11 years. Even assuming, though not admitting, that the limitation provision under the 2019 amendment did not apply to accidents preceding 1/4/2022, it is nonetheless pertinent to note that the claim petition appeared to be filed on 11/10/2022, that is more than 6 months and 10 days after the date on which the amended Section 166 Clause 3 came into force. This clearly shows that the respondent claimant was not acting with urgency even under the new legislative regime, but instead remained indifferent to the matter until the expiry of even the freshly prescribed statutory period. The learned tribunal failed to make any proper judicial observation on this point and acted as if no issue of delay existed at all. The learned tribunal merely and vaguely discussed this aspect by mentioning that there is nothing to show that the application is not maintainable in its present form and style, and the claim the application is held maintainable in the present form and style. This approach, coupled by what will be mentioned in the subsequent paragraphs, has caused serious prejudice to the appellants who have been called upon to defend a stale claim filed nearly 11 years after the incident without any real and sufficient opportunity to confront the alleged justification for delay. It may not be out of place to state herein that this issue was also raised by the present appellants at their written statement before the learned tribunal but was unfortunately not considered. Hence, because of this reason, the impugned judgment and award rendered in this regard statutory context, factual delay, and procedural fairness is therefore vitiated by a jurisdictional infirmity and is liable to be set aside. That, for the sake of repetition, it is humbly submitted that the learned tribunal completely overlooked this obligation and proceeded to accept, without proper scrutiny, a vague and improper explanation by the respondent claimant that she had entrusted the matter to our local advocate, who allegedly failed to take action and repeatedly gave verbal assurances. This explanation, which was titled "To Whom It May Concern," has been exhibited by the respondent claimant as Exhibit C9 for the learned tribunal. However, it is pertinent to mention that it was the responding claimant who exhibited the same before the learned tribunal and not the said advocate who appeared to write and issued the same. Lordship, this Exhibit C9 is at page 1
Yes.
However, it is pertinent to mention that it was the respondent claimant who exhibited the same before the learned tribunal and not the said advocate who appeared to write and issue the same. Although the contents of the same were explained and incorporated to some extent by the respondent claimant in her examination in chief on affidavit before the learned tribunal, no attempt was made to summon or examine the said advocate or his associates, and the learned tribunal made no inquiry or put forth any discussion pertaining to the respondent claimant's diligence or conduct during the intervening decade, and treated a serious jurisdictional lapse as a mere formality, thereby rendering its finding not only unsustainable but deeply inconsistent with the minimum standards of judicial reasoning applicable even to a benevolent legislation such as the Motor Vehicles Act. And, my Lord, point number 2 of my grounds: erroneous finding of fault against the driver and owner of the accident vehicle. That the learned MACT Izor was greatly biased and prejudiced against the appellants herein by holding that the accident in question occurred due to the fault of the driver and owner of the accident vehicle without any sufficient and legally admissible, credible or independent material to establish rash or negligent driving on the part of the driver, Sri Kela Lomsanga. It is also pertinent to mention herein that the said Sri Kela Lomsanga was not even impleaded as a party to the proceeding in the claim petition, which is a necessary mandate in filing a claim petition, especially under section 166 of Motor Vehicles Act 1988. It is also humbly submitted that the finding of negligence by the learned tribunal against the present appellants is based on conjecture, speculative reasoning, and an improper acceptance of partisan and contradictory materials without due regard to the burden of proof that rests upon the claimant under section 166 of the Motor Vehicles Act 1988. That it is well established that in a claim under section 166 of the Motor Vehicles Act 1988, mere occurrence of an accident or mere allegation of fault or negligence does not ipso facto establish negligence. The learned tribunal was required to evaluate whether the evidence adduced by the responding claimant discharged even the minimum threshold of preponderance of probabilities of negligence. However, the learned tribunal firstly failed to appreciate that the investigating officer, Sri H. Lantoimoy CW2, played the simultaneous roles of being a complainant, inquiry officer, and investigating officer in connection with the said claim petition, and the same poses a serious compromise to the independence and reliability of the investigation against the appellants herein. The said Sri H. Lantoimoy, who was the claimant's witness number 2, deposed in his evidence that the said Sri Kela Lomsanga rashly, recklessly, and negligently drove the accident vehicle, and also deposed that the said driver was found to have consumed alcohol at the time of driving the accident vehicle, which according to him can be seen from the medical examination report conducted by Dr. David Lalsangyan, a medical officer, Emergency Department, Civil Hospital, Izor. However, CW2 in his cross-examination had stated that he did not have any sufficient evidence to show that the said Sri Kela Lomsanga was drunk at the time of the accident. Further, CW2 also stated in his cross-examination the medical report was not enclosed in the claim petition and that it was not included in the charge sheet. Indeed, the same was neither enclosed in the claim petition nor exhibited at the time of the trial before the learned tribunal. Coupled with this fact, it is material to mention that to the best knowledge of the appellants, the said Dr. David Lalsangyan, a medical officer, Emergency Department, Civil Hospital, Izor, was not even cited as a claimant's witness and had failed to prove the veracity of the medical report before the learned tribunal. Secondly, the allegation of negligence and being drunk while driving the accident vehicle against the said Sri Kela Lomsanga had been rebutted and denied by Sri Kela Lomsanga himself, as he was the opposite witness number 1 before the learned tribunal. On the same vein, opposite witness number 2, Sri Lalmangaya, candidly admitted in his cross-examination that he had no knowledge as to whether the driver, Sri Kela Lomsanga, had consumed liquor prior to or at the time of the accident. Thirdly, it will not be out of place to state herein that according to the materials available on record, no MVI MVI requisition for mechanical inspection of the said accident vehicle was made, issued nor produced before the learned tribunal. This is particularly important for this instant claim petition because even though CW2 had made some observation in his inquiry report regarding his personal reasons as to why the accident vehicle met with an accident, attributing the cause to the negligence of the driver, he, in his evidence adduced before the learned tribunal, stated that he is not an expert in motor vehicular engineering and that he did not know the mechanical repair history of the accident vehicle, and also that he did not know whether the accident vehicle was unfit for carrying passengers at the time of the accident. Hence, because of this reason, it is humbly submitted that the non-production of the MVI requisition for mechanical inspection of the said accident in part vitiates the claim petition, rendering the impugned judgment and award erroneous. My grounds number 3 is with the disregard of discharge order passed by the learned magistrate in connected criminal proceeding, that the learned tribunal failed to sufficiently consider, much less give due weight to the undisputed fact that the driver of the accident vehicle, Sri Kela Longsang, was previously discharged by the competent judicial magistrate first class in the criminal case arising out of the same incident, being criminal trial number 2622/2011, which was registered on the basis of the same facts and allegations as those forming the foundation of the present claim, that it is humbly submitted that the discharge order was passed after the magistrate was satisfied that the materials in the case report did not disclose any offence justifying the continuance of criminal proceedings under the relevant provisions, and that this judicial finding rendered after application of minor scrutiny of the available evidence was placed on report by the appellants, but was somehow ignored by the learned tribunal while determining whether negligence has been established in claim proceedings. That while it is correct that the standard of proof in civil proceedings under Section 166 of the Motor Vehicles Act differs from that in criminal prosecution, and that a discharge or acquittal in criminal court does not automatically exonerate a person from civil liability, it is equally well settled that where the material facts and evidence in both proceedings are identical and the criminal court has found no prima facie case even to proceed to trial, the learned tribunal must at very least examine whether the responding claimant had produced any additional, independent or superior evidence to justify a different finding in the civil proceeding. In the present case, although evidence was that the evidence before the learned tribunal was largely limited to the same police records which had already failed to convince the learned magistrate that in this regard, although the learned tribunal addressed the said discharge order to some extent, it is humbly submitted that the learned tribunal erroneously and in a blanket manner merely accepted the oral depositions of the claimant witnesses, including the same police reports, without considering the rebuttal of the present appellants, and hold that the claimant has prima facie proof that the driver of the offending vehicle had driven the accident vehicle rashly and negligently. Further, it is also respectfully submitted that it would be improper to have a prima facie view regarding the allegation of negligence at the time of passing the impugned judgment and award, in spite of completing a full-fledged trial at the learned MACT Adjournment. Hence, because of the said reasons, the impugned judgment and award is liable to be set aside and quashed. My next ground is erroneous reliance of income certificates. That the learned tribunal has erred in relying on Exhibit C8. Exhibit C8 is at page 18 of the paper book. A certificate issued by the Young Hizou Association, Thai Manipus branch, to assess the income of the deceased at rupees 650 per day or rupees 16,900 per month, allegedly on account of his work as a head mystery for the YMS Zolbu construction project. This certificate, styled as a shed cleaner, was issued almost 11 years after the date of the accident and is not accompanied by any supporting wage slips, account books, or financial reports from the YMA to show that such remuneration was ever paid or recorded. Although CW4, Sri Lanmanki Matsoti, who was the then president of the YMA Manipus Aizol, claimed in his evidence that the 2010 until his death on 18/11/2011, he admitted in his cross-examination that the account books which would allegedly contain daily wage reports of the deceased was never enclosed with the plain petition, nor was it produced before a learned tribunal. That in this regard it is humbly and respectfully submitted that certificates issued by local bodies or associations such as the YMK, a socio-cultural body with no statutory competence to assess or certify individual income levels cannot be relied upon as proof of income has been clearly laid down by the Honorable Guwahati High Court in New India Assurance Company Limited versus Vakalatnama 2007 3 GLT 332. I have also produced a citation. The relevant portion of the said judgment is reproduced herein for ready reference. Even after a document is admitted in evidence, it remains to be appreciated with regard to its evidentiary value. It is not difficult for any person to obtain such a certificate from village council, and by merely producing such a certificate, the burden of proof on the part of the claimant does not stand discharged. I am of the considered view that such a certificate alone, without any supportive evidence that the village council is competent to issue income certificate, cannot be the basis for taking a view that the deceased was earning rupees 40,000 annually. That because of the said reason, the impugned judgment and order is liable to be set aside and quashed. Your Honour, my next ground is erroneous computation of compensation. That the learned tribunal has grossly erred in its computation of compensation by adopting an inflated monthly income of 16,900, which was neither admitted by the opposite party nor proved by any independent documentary or admissible evidence. The figure was derived solely from Exhibit C8. Exhibit C8 is at page 19 and 90A of the paperwork. A post facto certificate issued by the Young Widow Association YMA in 2022, more than a decade after the death of the deceased, and was not supported by any wage slips, payment records, or employer registers. The learned tribunal accepted this figure without proper scrutiny and failed to take any judicial estimation of income based on verifiable standards such as minimum wage notifications, industry-specific wage averages, or national income guidelines, especially in the absence of any formal employment contract. This approach violates the certain principle that compensation must be assessed not on the claimant's assertion alone, but on evidence that passes the judicial muster, and that any speculative income claim must be treated with due action. That the learned tribunal has committed a legal error by mechanically applying the principles laid down by the Honorable Supreme Court in National Insurance Company Limited versus Reliability and others, reported in 2017-16 SCC 680, to a case where the accident occurred on 18/11/2011, almost 6 years prior to the date of the judgment, which was delivered on 31/10/2017. It is respectfully submitted that the applicability of penalty is governed by the doctrine of prospective overruling, and a coordinate bench of the Honorable High Court, Aizawl Bench, has categorically held in Mem Appeal 41 of 2017, decided on 19/9/2018, that penalty will not apply retrospectively to accidents that occurred prior to its pronouncement. In that case, where the accident occurred in October 2015, the High Court refused to recalibrate compensation based on penalty, expressly stating that the decision will have only prospective effect. In the present case, where the accident occurred even earlier on dated 18/11/2011, the tribunal was bound by the same position in law and was not empowered to impose the standard laid down in penalty for determining future respect for conventional heads of compensation. Lordship, I have produced the judgment dated 19/9/2015.
which says that the pronicity has prospective overruling. Which para?
The fifth para. After hearing the learned counsel for the parties and perusing the reports, it appears that the accident in which the respondent's daughter died took place on 24/10/2015, which is before the judgment in Pronicity and others was passed. Since the judgment passed by the Honorable Supreme Court will only have prospective effect, the same cannot be applied in the present case. Therefore, the appeal is dismissed.
Yes.
Yes, and Lordship, I will continue. That despite the above limitation, the learned tribunal proceeded to apply the ratio of pronicity in full, adding 25% towards future prospect, adopting fixed head such as rupees 1 lakh for consortium and awarding amounts under loss of estate and funeral expenses on the footing of revised benchmarks introduced in pronicity. That this wholesale application was carried out without acknowledging that pronicity itself did not lay down any retrospective applicability, and without noting that the Honorable High Court had already declared the precedent inapplicable to pre-2017 accidents in a binding judgment. This misapplication has not only resulted in a compensation quantum that exceeds what was legally permissible under the law applicable at the time of the accident, but also amounts to judicial overreach by disregarding the temporal boundaries of binding precedent. Notwithstanding what have been submitted above, it is pertinent to mention herein that as per the said judgment, a cap of rupees 40,000 for loss of consortium was fixed, and the learned tribunal has erroneously and excessively awarded the respondent claimant the said 1 lakh despite the standard fixed set by the said judgment. That in conjunction to what had been submitted above, it is submitted that the learned tribunal erred in law and on facts by assuming without scrutiny or evidentiary analysis. It is a case of the claimant that the deceased left behind 5 financially dependent children, and accordingly applying a 1/3 deduction for personal expenses while computing loss of dependency. The claimant herself, in her examination in chief, specifically disclosed the birth dates of her 5 children as Lal Munsiami 21/5/1982, Lal Robsanga 6/8/1983, Lal Parmoyi 12/1/1988, Lal Biakmoyi 15/4/1989, and Lal Remdwanga 1/8/1994. That accordingly on the date of the accident, 18/11/2011, 4 of the 5 children were well above the age of majority and cannot be presumed to be financially dependent on the deceased. In the absence of any evidence to the contrary, the tribunal failed to examine this clear factual admission made by the claimant herself and proceeded to mechanically treat all 5 children as dependents, thereby reducing the deduction for personal expenses to 1/3 and inflating the Then C. Compensation. In the absence of any corroborative evidence showing that the 4 adult children were either unemployed, incapacitated, or otherwise financially reliant on the deceased, the learned tribunal was not entitled to presume dependency based on mere kinship, and the burden lies upon the claimant to establish dependency, and failure to discharge that burden cannot be cured by judicial assumption. That also again, in conjunction to what have been submitted above, it is humbly submitted that the learned tribunal committed a material error in law and fact by accepting the deceased aged as 47 years at the time of death, without adequately reconciling the conflicting records available on file, and by mechanically applying the multiplier of 13 as per Sarla Verma versus DTC 2009 6 SCC 121, without arriving at a clear and supported finding on age. The record discloses multiple and contradictory age documents, including a marriage certificate where the deceased year of birth is recorded as 1959 and a birth certificate introduced during the claim proceedings showing a birth date 19/5/1964. On the other hand, the respondent claimant stated in her cross-examination that in Exhibit C4, C5, and C6, the age of her deceased husband has been recorded as 52 years of age on date of the accident. The learned tribunal, without examining the authenticity, sequence, or admissibility of these records, chose the most favorable document to the claimant and fixed the deceased age as 47, enabling the use of a higher multiplier and 25% addition for future prospects. This selective reliance without reasoning amounts to judicial inconsistency and has had a direct and substantial impact on overall computation. That because of the said reasons, the present appellants have been gravely prejudiced, and notwithstanding the submission of the prayer for setting aside and quashing the impugned judgment and award, it is prayed in the alternative that the quantum of compensation be reduced as per the applicable laws, that in culmination of what have been submitted above and because of all the above mentioned reasons, it is submitted that the impugned judgment and order dated 14/2/2025 is unsustainable in the given facts and circumstances, and as such the same is liable to be set aside and quashed, or in the alternative modified. Lordship, with regards to the age of the deceased, it's at page 6 of the paper book. Page 6 is marriage certificate. 6A is the English translation.
Yes.
Here, his date of birth is 22 May 1959, and it was issued in the year 1982, 12/1/1982. And at annexure 3, page 8 is his birth certificate, issued in the year 15/12/2011. Here, his date of birth is 19 May 1964.
Now, which is to be believed?
The marriage certificate, because my lord, it was issued in the year 1982, and the learned tribunal had also not looked into this matter.
Okay.
And with regards to the monthly income, page 19, Exhibit C8, the English translation is at 19A.
19.
Yes, 19.
Yes.
This acknowledgement is made by the President, Young Mizo Association, Tan West Branch, and it is not being supported by any wage slip, payment reports, or employer registers. And the learned tribunal accepted without proper scrutiny and failed to undertake any judicial estimation of income based on verifiable standards. Yes, sir. That is my grounds.
Okay, yes.
May I please, Lordship?
Yes.
My Lord, to begin with, I would like to submit to your Lordship that the respondent claimant is the wife of the deceased and as far as the limitation objection is concerned, I would like to read one certificate issued by the one advocate who was earlier engaged by the respondent for taking up the case. However, he failed to do so, and that is why he issued this certificate at page 20 of the paper book, my Lord. Page 20 of the paper book, which was exhibit C9. I'm reading with your Lordship permission.
Yes.
This is to certify that I had initially engaged by Srimati Zongming Thangi, wife of Kelal Eng Moya, permanent resident of Chanmaru West, Aizawl, for filing claim application for compensation for the death of her husband, Kelal Eng Moya, in the road traffic accident on 18/11/2011, involving the MST bus bearing registration number so-and-so. In fact, I had been furnished all the required documents such as FIR, motor registration certificate, birth and death certificate of Sri Kelal Eng Moya for the said purpose, soon after the said motor accident. Unfortunately, I had misplaced all the documents while shifting my place of residence from Chanmari West to my present place of residence. My junior advocates, who seem to have misplaced the said file containing those documents, made untiring efforts to locate the same, but to no avail. As a result, I have recently informed Srimati Zongming Thangi about the lost misplacement of her documents sometime in the second week of August 2022. As a matter of fact, my said client, Srimati Zongming Thangi, or her children, repeatedly inquired about the outcome of the claim entrusted upon me, and I had always assured them for fruitful result. As such, the delay in filing the present claim application should not be attributed to the claimant, Srimati Zongming Thangi, as it is beyond her control. Inconvenience caused to her is greatly regretted. This was the certificate issued by the
advocate concerned, who was earlier engaged by the respondent to take up her case, filing claim application before the claims tribunal. That was the reason for delay, my lord. And at the same time, my lord, as your lordship knows very well, that there is no limitation at all. Prior to the 2019 Amendment Act, there was no fixed limitation period for filing a claim application before the Motor Accident Claims Tribunal. The 1994 amendment had previously deleted the earlier time limit, allowing claims to be filed without restriction. This was also mentioned by the learned counsel for the appellant in her appeal petition. And my lord, the accident as it took place way back in 2011, at that point of time, there was no fixed limitation period. The said 2019 Amendment Act, this limitation, amended provision of Limitation Act is not applicable to the present case because accident took place before 2019. And my lord, I have before, taking lordship to the impugned judgment or before that, my lord, I'm taking your lordship to the deposition of the respondent claimant is at page 27. Starting from page 27, there is the deposition of the claimant respondent. I'm not reading the whole statement. I'm reading from paragraph 7 at page 29, my lord.
Yes.
Page 29, paragraph 7. That is for the inordinate delay in filing the instant claim application. We had earlier engaged an advocate, Mr. Zela Rembuata, who had rented a room in our locality at Chanmari West, Aizawl, before shifting to his present place of residence. In fact, we had given him all the required documents for filing the claim application. Soon after the death of my said husband in the road traffic accident, we had repeatedly inquired from the said advocate about the progress of the claim case, and he had assured us that his junior advocate had been taking care of the case and told us to wait for the outcome of the case. As can be seen from the certificate duly issued by the said advocate, the delay in filing the present claim case cannot be attributed to me for the reasons stated therein. That was the statement made by the respondent claimant, my lord, so far as the delay, inordinate delay in filing the claim application, my lord. She has justified the delay and explanation was made thereunder. And my lord, as far as the delay in negligence, of the driver is concerned. As we have just heard from the Learned Counsel for the appellant, stating that he was discharged from the criminal liabilities of the criminal case registered against the driver of the accident vehicle, my lord. Here, I would like to take your lordship to the order discharging the driver of the accident. I'm taking your lordship to page 26. This page 26 is the order passed by the criminal court discharging the driver of the accident vehicle.
Yes.
I'm reading the operative part.
Yes.
It's not very long. I'm reading the whole order, my lord.
Yes.
2310 to 2012. Today is fixed for consideration of charge. Learned counsel for the accused are present. Heard both parties. Learned counsel for the accused stated that the accused had not committed any fault, except driving unfit vehicle, which was declared fit for carrying passengers. They submitted that the vehicle was under repairs for a long time, and the time when accident took place was the first time that vehicle was used as public transport after a long duration of its repairing. They further stated that the accident was caused by brake jam and not the negligence nor drunk of the accused. However, they prayed to discharge the accused from all liabilities leveled against him in this instant case. That was the submission made by the counsel for the accused. And the learned APP submits that the accused should not be discharged as the accident took place due to his negligence. And the operative part is after hearing both parties and also from the statement of the accused. It appears that the vehicle in question met with an accident while the same was hired out by government, that is Transport Department. The accused was also detailed to drive that vehicle by the higher authority, and that vehicle was under repair for a long time. In the above circumstances, I hereby discharge the accused from all liabilities leveled against him in this instant case. My lord, what I would like to submit to your lordship is the said driver of the accident vehicle was discharged from the criminal liabilities not on merit. No evidence was recorded from the witnesses of the criminal case. That was confirmed by the IO. Well, when he was produced before the tribunal, he submitted to the court that he was not issued any summon. He was not called upon to appear before the court to verify whether the driver of the accident vehicle was at fault or accident was due to negligence or not. He was not given a chance to confirm his charge sheet at all. That means no evidence was taken at all. Nothing was done so as to proceed with the merit of the case. And my lord, I am taking your lordship to the deposition of the IO, inquiry officer of the state, inquiry officer of the state criminal case, is found at page 45, my lord. page 45.
Yes.
I'm reading with your lordship permission from para 2. Para 1 is para 1, that during the year 2011 I was posted at Sarang Police Station as officer in charge. Para 2, that on 18/11/2011 at about 6:30, after finishing our duty at Dropwit Chief, we were on our way to Sarang. We found that one MST bus bearing registration number so-and-so, driven by driver Kela Lomsanga, son of so-and-so, met with an accident at Simui near Mr. Selchunga's garden. Inquiry was immediately conducted and found that the driver Kela Lomsanga drove the said bus rashly, recklessly, and negligently. In fact, the driver Kela Lomsanga was sent for medical examination on whether he has consumed alcohol. As a result, the said driver was found to have consumed alcohol at the time of driving the said accident vehicle. This can be seen from the medical examination report conducted by Dr. David Lalsang, a medical officer, Emergency Department Civil Hospital, Aizol. Para 3, that as a result of the said accident, one of the passengers, namely Kelal Eng Moya, sustained grievous injury and evacuated to the Sairang PHCC, and he succumbed to his injuries thereafter. Para 4, that after careful examination of the place of accident, tire marks appeared on the road and also took measurement of the road where accident took place, and also from the statements recorded from the passengers. It is found that the driver, Kela Lomsanga, was found to have driven the accident bus rashly, recklessly, and negligently. As a result, Sairang PS case number so-and-so was registered under section so-and-so against the driver, Kela Lomsanga. Para 5, that after completion of investigation, I have submitted charge sheet number so-and-so to the Chief Judicial Magistrate, Aizol. However, I have neither been summoned by any criminal court to appear or to give evidence in connection with my said charge sheet till today. That was in 2023, my lord, after more than 10 years. He was never summoned by any criminal court to prove his charge sheet. That will clearly indicate that the driver was discharged without any merit, simply discharged. And my lord, a few passengers who were on board were examined by us. They are eyewitnesses, my lord. At page 38 is the witness, claimant witness, K. Sang Luni, 64 years, permanent resident of Chanmari West. I'm reading with lordship permission.
Yes.
Para 1, that I know the claimant and her deceased husband, Kelal Eng Moya, as we belong to the same locality. Para 2, that I boarded the offending MSD bus bearing number so-and-so, belonging to the opposite party, on 18/11/2011, after having picnic organized by the Chanmari West Wayme Kuang Sierra section at the Lengkui West End picnic spot. In fact, right from the start, the driver, Kela Lomsanga, drove the accident vehicle rashly, recklessly, and negligently, resulting in the road traffic accident. As a result, the claimant and her said husband sustained grievous injuries, and the husband of the claimant succumbed to his injuries on the way to the PHCC, Sairang. Fortunately, I suffered no injury on my body. As far as my knowledge about the vehicular accident is concerned, I am the eyewitness, as well as one of the victim passengers of the offending vehicle. under the facts and circumstances of the case, the driver, Kela Lonsanga, is guilty and liable for the vehicular accident. At page 39, para 3, that I also know that some of the passengers who initially boarded the offending vehicle driven by Mr. Kela Lonsanga dare not continue to travel in the same bus due to reckless and careless driving, left the bus and boarded the second bus for destination. That these statements were not rebutted by any witness at all, my lord. And my lord, at page 42, another witness who was also an eyewitness statement is here, deposition. Srimati Zosangwali, 39 years. I'm reading with lordship permission. Para 1, I know the claimant and her deceased husband, Kelal Eng Moya, as we belong to the same locality. Para 2, that I boarded the offending MSD bus bearing number so-and-so, belonging to the opposite party, on 18/11/2011, after having picnic organized by the Chanmari West Wayme Kwang Chera section at Lenghui West End picnic spot. In fact, right from the start, the driver Kela Lomsang seemed to have consumed liquor and drove the accident vehicle rashly, recklessly, and negligently on the way to the said spot, picnic spot. As such, I, along with some other passengers, decided not to risk our lives and boarded another bus. Thereafter, we felt so lucky to have abandoned the accident vehicle driven by K. Lalonsanga on that day, as the bus driven by K. Lalonsanga met with an accident and his passengers sustained grievous injuries on their bodies. My lord, that was the statement made by another eyewitness. This deposition evidence duly adduced by the eyewitnesses.
When the accident occurred, while on the way to picnic or while returning back?
Oh, while returning back, my lord. On the way, no accident took place, but they were afraid because the way.
Okay, so while going to the picnic spot itself, he was driving in a rash and negligent manner.
My lord, on the way also.
Whether these witnesses were cross-examined?
They were cross-examined. Cross-examination also there, my lord. I have not read. If need be, I can read them. They are there.
Whether her deposition remained intact?
Intact, my lord. They didn't budge an inch. They didn't change. The credibility could not be shaken.
Okay.
And my lord, as far as the negligence of the driver is concerned, this eyewitness is verified that he was negligent. And my lord, as far as the income of the deceased is concerned, we have produced a certificate issued by the YMA.
But how YMA would know the income?
Because he was engaged. Deceased person who was a mystery was engaged by the YMA for construction of YMA Zolbuk building, my lord, at that point of time. So the ruling placed by the Learned Council for the appellant cannot be taken into account, because in that case, usually income certificate was issued by the village council authorities without actually knowing the income of the deceased. In the present case, it was the YMA who engaged the deceased as a mystery stone mason. So the ruling placed by the Learned Council for the appellant cannot be taken into account. The same is not similar to each other. And my lord, here we have produced the precedent of the Young Mizo Association YMA. Oh yes, at page 34, my lord. As far as the income of the deceased, it was the YMA who issued the certificate, and that is why we have produced the president of the YMA to adduce evidence in this connection in order to prove the income of the deceased. At page 34, with your lordship permission, I'm reading.
Yes.
That I'm, para 1, starting from para 1, that I'm presently holding the post of Vice President YMA, Chanmari West Branch, Aizawl, Mizoram. In fact, I have actively been involved in the branch YMA activities since the year 1991 till then. That I know the claimant Pizo Ming Tangi and her deceased husband KLL Emoya was personally known to me since the year 1983, as we live in the same locality at Chanmari West, Aizawl. That the deceased KLL Emoya, who was a cement mystery, was engaged as head mystery work supervisor by the branch YMA Chanmari West, Aizawl, for construction of Zolbuk building at the rate of rupees 650 per day, commencing from 12/5/2010 till his death in the road traffic accident on 18/11/2011, my lord.
Okay.
As such, Fiat Puina, that is certificate issued by the income certificate issued by the YMA, which was exhibit C8, was issued by the branch YMA Chanmari West, Aizawl. Cross-examination, my lord, I'm taking to your lordship at page 36. Continuation of examination chief of Sri Lalmonti Machote. Exhibit C8 is issued by me as president, YMA Chanmari West branch. Exhibit C8A is my signature, and Exhibit C8B is the signature of Sri Kelalung Muana, the then secretary of the YMA Chanmari West branch, as I can recognize his signature as he is personally known to me. Cross-examination. The claimant Zong Ming Tangi is a daily laborer. Claimant is the daily laborer. Number 2, at the time of construction of Zolbuk building, I was president, Chanmari West branch. He used to maintain account book for recording day-to-day transactions of receipt and payment. He used to draw his wages from the amount collected from the branch treasurer. He used to maintain account book of all the laborers, including himself, but the account book maintained by Sri Lalengwai was not enclosed in the claim petition. That he used to draw rupees 650 per day, commencing from 12/5/2010 till his death. It is not a fact that I am deposing falsely before the court today. My lord, if it was the income certificate issued by the YMA, well exhibit before the court, the same was, no objection was raised by any quarter. From the opposite party also, no objection was raised. And my lord, as far as the date of birth is concerned, the claimant herself clarified in her deposition. My lord, permitted to read out. On re-examination, at page 32, the deposition of the respondent claimant, continuing at page 32, re-examination portion. Page 32, my lord.
Yes.
Number 1, the date of birth recorded in our inmate certificate, means marriage certificate, was written by the presiding minister on presumption, as my deceased husband did not seem to look younger than his wife. In the exhibit CM, C5 and C6 also, the age of my said husband was recorded as 52 years on the date of accident. However, there is no document or birth certificate to indicate that my husband was 52 years of age at that point of time. There was no birth certificate at all. Since he was not educated, there could not be any birth certificate at that point of time. So on presumption, the date of birth was recorded, it seems, by the presiding minister. And my lord, I'm coming to the ruling in support of my submission. The first ruling I would like to place.
No, you
my lord.
obtained birth certificate later on in the
Later
year.
on, yes, my lord. I do not deny that.
So, on what basis birth certificate was issued? There is no evidence.
There is no evidence.
You are saying that no documents were there with you.
Right, my lord. At that point there was no document at all.
But in the birth certificate, normally it is written that this birth certificate is issued on the basis of information from original records.
My lord, that kind of record is not available at all for those especially who do not go to school or college. Even if we go to school or college, actually it depends upon the the way it is recorded in the HSLC exams.
On date of birth certificate, what was the cross-examination?
We can see. Hello.
Who exhibited it? The claimant?
Birth certificate is at page the examination in chief we have read of the respondent claimant. At page 30,
yes.
She was cross-examined by the government advocate, my lord. We can see at page 30 of the
Yes.
paper book. Down under, starting from cross-examination by government advocate. It is a fact that K. Lomsanga, driver of the accident vehicle, is not implicated as a party. Number 2, it is a fact that as per marriage certificate enclosed in the petition, the deceased K. Mingliana was born on 28 June 1959. That was based upon the marriage certificate. And at page 31, my lord.
Para 4.
Para 3.
Para
yes,
4.
Para 4, it is also a fact that as per the birth certificate of the deceased, Kelal Moya, it was written as 19 May 1964 and it was issued on 15/12/2011.
Nothing else was?
Nothing else, my lord.
Okay.
I do agree with the lordship. We have no any other evidence to that effect. My lord, the ruling I would like to place in support of my submission is, number 1 is Maitri Kohli and another versus New India Assurance Company and others, 2003, volume 8, SCC, page 718.
Michael, I'll be requiring photocopies.
Para 4, my lord.
This
Para
2003
2003, Volume 8, SCC, page 718, para 4, my lord. Law prevailing at the time of accident would be applied. Since the accident took place way back in 2011, the law applies should be the law where no restriction for filing claim application at the relevant time, my lord. I'm reading with lordship permission, para 4. On behalf of the appellants, it is contended that the tribunal had applied the wrong multiplier. It was submitted that on the date of tribunal gave the award, the Motor Vehicles Act 1988 had already come into force. It was submitted that the schedule for payment of compensation should have been applied. It was submitted that the multiplier should have been 16. We are unable to accept the submission. It has been held by this court in the case of Padma Srinivasan versus Premier Insurance Company Limited that the law prevailing on the date of the accident has to apply. This is the principle I am praying to your lordship to apply in the present case, that the law at the relevant time is to be applied. Means there is no limitation to be applied at the point of time. 2011, there is no restriction. And my lord, my second ruling is Anita Sharma and others versus New India Assurance Company Limited and another. Reported in 2021, Volume 1, SCC, page 171, para 21.
Yes.
Strict proof. My lord, para 21. Strict proof is not required in MSAT. I'm reading, it's not very long. Para 21 at page 182. Equally, we are concerned over the failure of the High Court to be cognizant of the fact that strict principles of evidence and standards of proof, like in a criminal trial, are inapplicable in MSAT claim cases. The standard of proof in such like matters is one of preponderance of probabilities rather than beyond reasonable doubt. So in the present case also, the standard of proof is one of preponderance of probabilities rather than beyond reasonable doubt. And one more, the ruling in this connection, I would like to place is TSC 2018, Volume 3, TSC, page 18, SC, para 8. Hyper-technical approach is not allowed, my lord. I'm reading para 8.
Yes.
Para 8, with lordship permission.
Yes.
The appellants may be right in contending that in cases where the accident occurs without any fault of the owner of the vehicle or the fault of the other vehicle, the liability to pay compensation at best must be determined in terms of Section 140 of the Act, as has been held in A. Sridhar Supra. It is true that the High Court in the present case has overturned the finding recorded by the tribunal that the motorcycle was driven by appellant number 2 at the relevant time when the accident occurred, and instead concluded that the motorcycle was in fact driven by the deceased, Krishna Kumar. In that sense, The accident occurred neither due to the fault of the owner of the vehicle, who admittedly was not present or traveling on the motorcycle at the relevant time, nor due to the fault of any other vehicle. However, on a deeper scrutiny of the materials on record, we are of the opinion that the High Court committed manifest error, an error apparent on the face of the record, in reversing the finding recorded by the tribunal, that the motorcycle was being driven by appellant number 2 and had caused accident due to rash and negligent driving. We are conscious of the fact that the respondents, claimants, have neither come up in cross appeal against the reduction of the compensation amount on the finding of contributory negligence, nor have they filed any cross objection regarding reversing of the crucial finding of fact by the High Court. However, it is well settled that in motor accident claim cases, the court cannot adopt a hyper-technical approach, but has to discharge the role of parens patria. My Lord, I'm not reading further. What I am emphasizing from the point is, it is well settled that in motor accident claim cases, the court cannot adopt a hyper-technical approach, but has to discharge the role of parens patria. And my Lord, one last ruling of law to place to your Lordship is 2023, volume 13, SCC, page 510, para 12. My Lord, with Lordship permission, I'm reading para 12, which is relevant to the present case, page 514.
Yes.
In this context, we could refer to the judgment of this court in NKV Bros P Limited versus M. Karumai Amal. This ruling was also relied upon by the tribunal in passing the present impugned judgment, my Lord, wherein the plea that the criminal case had ended in acquittal and that, therefore, the civil suit must follow suit was rejected. It was observed that culpable rashness under Section 304A IPC is more drastic than negligence under the law of torts to create liability. Similarly, in Bimla Devi versus Himachal RTC, it was observed that in a claim petition filed under Section 166 of the Motor Vehicles Act 1988, the tribunal has to determine the amount of fair compensation to be granted in the event an accident has taken place by reason of negligence of a driver of a motor vehicle. A holistic view of the evidence has to be taken into consideration by the tribunal, and strict proof of an accident caused by a particular vehicle in a particular manner need not be established by the claimants. The claimants have to establish their case on the touchstone of preponderance of probabilities. The standard of proof beyond reasonable doubt cannot be applied well considering the petition seeking compensation on account of death or injury in a road traffic accident. To the same effect is the observation made by this court in Dulcina Fernandez versus Zokuim Xavier Cross, which has referred to the aforesaid judgment in Bimla Devi. My Lord, it is very clear from the ruling passed by the Supreme Court in various judgments, including the present one, that the plea that the criminal case ended in acquittal and therefore the civil suit should follow was rejected outright by the Supreme Court, my Lord. So, just because the driver of the accident vehicle in the present case was discharged by the criminal court without taking any evidence at all, cannot be taken into account, and the same should be followed in the civil suit as rejected by the Supreme Court, my lord. And with that, I conclude my submission to your lordship. I wonder if I have missed out certain relevant points, but if any queries your lordship might have, I am ready to answer. And my lord, as far as the negligence of the advocate in not filing the claim application in time is concerned, there are a few rulings passed by the Honorable Guwahati High Court as well as the Supreme Court that the litigant should not suffer because of the negligence of the negligence of the advocate, which I have not produced today, but if lordship requires, I am ready to produce the same. And with that, I conclude my submission to your lordship, and I pray once again that the respondent is the wife of the deceased, and the deceased husband is the sole breadwinner of the family at the relevant time of accident. At the time he was died in the accident, and she suffered a lot. She had to shoulder looking after her children alone, and she had suffered lots of things at that point of time, and even till today she somehow managed with the help of her relatives who are around them in their locality. With that, I pray the lordship to dismiss the present appeal.
Yes, anything?
Lordship, with regards to the income, I would like to add more points. That the income of the deceased, it was assessed at rupees 16,000 per month based on a certificate issued by the Young Mizo Association. This certificate was issued more than 11 years after the death of the deceased. YMA is not a statutory authority competent to certify income. No wage slips, account books, or payment records were produced. The issuing witness admitted that the relevant account books were not placed before the tribunal. The tribunal failed to fall back on national income or minimum wage standards. And the certificates issued by local bodies or associations such as the YMA, a socio-cultural body with no statutory competence to assess or certify individual income levels, cannot be relied upon as proof of income, as has been clearly laid down by the Honorable Guwahati High Court. That I have already.
That you have already made
yes,
submission.
And with regards to the date of birth,
that also you have made submission.
Yes.
Anything else you want to say?
no, my lord.
Okay. Heard Miss Caroline L. Lungwai Pui, K. Lungwai Pui, London Government Advocate appearing for the appellant. Also heard Mr. L. H. Lian Shrima, London Senior Counsel, assisted by Miss Ruth Lalruat Feli, London Counsel for the respondent. Hearing concluded, judgment reserved. If you want to give anything in your support, any additional judgment, you may give by tomorrow.
My lord, I will.
Ask for the printed copy of these judgments. They will be bringing it from the library. And I think keep it in the records.
Yes, yes.
Lordship, there is one more item for you. But it's almost one. So shall we take up the matter first, or shall we have a break first?
Which item?
It's the next item, item number 6, I believe.
Call that item, whether they are in.
Item 6.
Michael, keep these also with